start. It is urged by him that the High Court has fallen into error by opening that there was no justification to exercise jurisdiction under Article 226 of the Constitution of India, whereas the facts stated warranted dereliction of such an observation by the DRAT, as a tribunal has no jurisdiction to grant such liability, and especially when a settlement between the borrower and auction purchaser had been arrived. Land Council would submit that the DRAT had really not addressed to any issue, and after recording a settlement in a most brief manner recorded the observations which really deserved to be quashed by the High Court. It is further canvassed by the Council that the High Court should have taken note of the fact that the order passed by the DRAT had already been compiled with, and it was absolutely unnecessary to drag the bank to a further litigation which is contrary to the spirit of the act and the purpose of recovery of debts due to banks and financial institutions act 1993. It is also contended that the DRAT failed to take note of the prayer made by the appellant therein, and for no important reason the matter was kept pending for more than 4.5 years. The Land Council, appearing for the respondent number 1, contended that he had paid the dues of the bank within the time fixed by the DRAT, and thereafter he had also transferred the property in favor of a third party due to financial difficulties. In essence, submission of Land Council is that putting the clock back is likely to cause serious loss to him. The Land Council, appearing for the auction purchaser, submitted that on the basis of the liability he had already filed a suit in the Delhi High Court and is entitled to pursue the remedy because the action was taken in hot haste by the bank in putting the property into auction without indicating that litigation was going on between the borrower and the bank. It is urged by him had the said fact was made known, the third respondent would not have participated in the auction. It is argued by him that his claim for damages cannot be nullified by the decision of the High Court. The girl had expressed a marked reluctance to stay with her father. The High Court was of the opinion that the children had developed long standing affection towards their maternal grandfather, aunt, and uncles. It will take a while before they develop the same towards their stepmother. The sex of the minor girl, who would soon face the difficulties of attaining adolescence is an important consideration, though not a conclusive one. She will benefit from the guidance of her maternal aunt if custody is given to the respondent, which the appellant will be in no position to provide. Further, there is special bonding between the children, and it is desirable that they stay together with their maternal grandfather, uncles, and aunt. In case of custody of the minor children, the family law, the Mohammedan law, would apply in place of the Act, considering the provisions under Section 353 of the Mohammedan law. The High Court had held that the preferential rights regarding the custody of the minor children rests with the maternal grandfathers. After making a doubtful proposition case in case of a conflict between personal law and welfare of the children, the former shall prevail. The High Court held that in the case at hand there is no such conflict for the reasons aforementioned. The High Court, by its impunged order, set aside the order of the Family Court Bangalore, which vacated the interim injunction issued against the appellant. It is this order of the High Court which is challenged before us by way of special leave petition, which on grant of leave has been heard by us in the presence of the Land Council appearing on behalf of the parties. It was the contention of the appellant before us that the Act will apply to the present case because there is a conflict between the preferential guardian in Mohammedan law and the Act. It was pointed out that while deciding the custody of the minor children, the welfare of the children had to be taken into consideration, and that it was guaranteed by the Act. They have placed their reliance on case of Rajasthan. The Rajasthan High Court in the cited case held that where the provisions of personal law are in a conflict with the provisions of Guardians and Wards Act, the latter shall prevail over the former. Stop.